do not
I am a
consent.
sovereign citizen and attorney at law.
Sir, I just need your license and registration, please.
Under common law jurisdiction, I am not required to provide that.
You are required. Hand it over now.
You have no authority over me.
Step out of the vehicle.
I am not stepping
Sir,
out.
step out.
You
right
have
now.
no...
Doors coming open.
This is unlawful.
Resisting. You...
The body cam is already rolling. 12:47 p.m. A Georgia interstate. The shoulder lit by strobes, blue, red, repeating. A black Mercedes sits parked at an angle, slightly crooked, like it stopped in a hurry or didn't entirely want to stop at all. The officer approaches the window. What he hears stops him mid-step. I do not consent. I am a sovereign citizen and attorney at law. You have no jurisdiction over me. Not nervous, not confused, rehearsed. The man behind the wheel is in a suit, tie loosened, collar button open, but the jacket is still on. He's not reaching for a glove box. He's not fumbling for a wallet. He's holding a laminated document up to the window, printed, prepared, brought here intentionally, and he is reciting from it like a man who has done this before, or at least practiced doing it. The officer's voice, when it comes, is flat and unhurried. Sir, I need your license and registration. I am traveling, not driving. Traveling is a constitutionally protected right. Your traffic statutes apply to commerce, not to a living man on a public road. The officer doesn't argue the point. He asks again. Same words, same tone. A second unit pulls up behind the Mercedes, and even that, the arrival of backup, doesn't shift the driver's posture. He turns his phone toward the officer and begins recording. He cites case names. He references UCC codes. He speaks with the calm fluency of someone who has studied this extensively and believes every word of it. Then the officer gives the order. Sir, step out of the vehicle. You do not have lawful authority to compel my exit. I am not subject to... Step out of the vehicle. The door opens, not by choice. 30 seconds later, a man in a pressed charcoal suit is standing on the shoulder of a Georgia highway with his hands restrained behind his back, still talking, still citing, still insisting, to a patrol officer, to a dash cam, to anyone within earshot, that none of this is legal. Here is where the story shifts. This is not a man who stumbled onto sovereign citizen ideology through a YouTube rabbit hole last week. He is a licensed, practicing attorney, passed the bar, argued motions, stood before judges. He knows how courts work because he has worked inside them, which makes the question sharper, not simpler. Why would a man with a law degree hand a laminated non-consent notice to a traffic officer at midnight and genuinely expect it to hold? And what happened when the ideology he cited in that Mercedes collided with the legal system he was trained to navigate? The arrest was only the beginning. What followed, the charges, the courtroom, the conduct review, would put both men under scrutiny in ways neither anticipated. And at the center of it all was a question the judge would eventually have to answer out loud. When a lawyer rejects the authority of the courts, what exactly is left of his license? To understand what happened on that highway, you have to understand what this man believed. Not what he claimed for the camera, what he actually believed. Sovereign citizen ideology is not a fringe legal theory invented last decade. It has roots stretching back to the 1970s, built on a selective and deeply distorted reading of constitutional law, commercial code, and post-Civil War amendments. Its core argument is this, that the government, at some point in American history, quietly converted its citizens into legal fictions, corporate entities, numbered assets on a balance sheet, and that a person who knows this, who formally declares themselves a sovereign national, can step outside that system entirely. No driver's license required, no court jurisdiction accepted, no statutes applied. It sounds radical, but inside the movement it is taught as liberation. The man in the Mercedes, we'll call him Richard Calloway, a name that reflects the composite of cases like this one, had been practicing law for 11 years, corporate litigation primarily, contracts, disputes, business filings. He was not a criminal defense attorney. He had not spent his career in traffic court or constitutional argument, but somewhere in the years between passing the bar and that night on the interstate, he had found the sovereign citizen framework, and it had reorganized the way he saw everything. In his view, a driver's license is a voluntary commercial contract with the state. Traffic codes are statutes that govern commerce, not the movement of private individuals. The officer who pulled him over was operating under corporate maritime law, a legal system Calloway believed had no authority over a living, breathing man who had formally revoked his consent to be governed by it. Now here is where it gets complicated. Some of what Calloway cited that night was real. There are genuine constitutional protections around travel. There are legitimate scholarly debates about the scope of state police power. A handful of the cases he referenced actually exist in legal databases. But citing a real case and applying it correctly are two different things entirely. The Supreme Court has never held that a private individual can opt out of traffic law by declaring common law jurisdiction. No federal circuit has recognized the living man doctrine as a valid legal defense. The UCC codes Calloway quoted on that shoulder, designed to govern commercial transactions between businesses, have no application to a routine traffic stop. Every argument he made was built on a foundation that looked like law from a distance. It just wasn't. And here is the detail that matters most. Calloway knew how to read case law. He had done it professionally for over a decade, which means the inconsistencies in his argument were not the result of ignorance, they were the result of selective belief, the kind that takes real information and bends it until it confirms what you already want to be true. Sovereign citizen ideology doesn't survive contact with legal scrutiny. It survives contact with people who want it to be real. Calloway wanted it to be real. So when that officer asked for his license, Calloway wasn't being irrational by his own internal logic. He was, in his mind, standing on solid legal ground, documented, laminated, prepared in advance. The problem was the ground wasn't there, and the officer on that highway wasn't debating philosophy. He was enforcing Georgia traffic code, which requires every operator of a motor vehicle on a public road to carry and present valid identification upon lawful request. No exceptions, no opt-outs, no laminated notices of non-consent. At this point, the stop could have ended with a citation. Instead, it moved towards something far more serious. Before we continue, enable to like and subscribe to this channel and also comment where in the world you're watching from. Now let's continue. The arrest itself took less than 2 minutes, but what followed took months. At the station, Calloway refused to provide his name to booking officers. He refused to sign any documentation. He placed his laminated non-consent notice on the processing counter and informed the desk sergeant, calmly, methodically, that he was being held unlawfully and that every officer present was personally liable for damages under common law tort. The desk sergeant had seen this before. Georgia's failure to identify statute is not complicated. If you are lawfully detained or arrested, you are required to provide your name, not your full biography, not your social security number, just your name. Refusal is a separate criminal charge, a misdemeanor, but a charge nonetheless. It stacks on top of whatever initiated the stop. Calloway refused anyway. So now the arrest that began with a lane violation and a refusal to produce a license had grown into a multi-charge booking. Failure to maintain lane, no proof of insurance, driving without a valid license, obstruction of a law enforcement officer, and failure to identify. 5 charges from a traffic stop. And Calloway, sitting in a holding cell still in his charcoal suit, was already drafting his defense in his head. He invoked his right to counsel, then waived it. He told the magistrate at his first appearance that he would be representing himself, that he did not recognize the jurisdiction of the court, but was appearing specially, not generally, a sovereign citizen procedural maneuver designed to contest the court's authority without technically submitting to it. The magistrate had seen this before too. Here is what self-representation looks like in cases like this one. It rarely resembles what people imagine. The defendant files motions, sometimes dozens of them, motions to dismiss for lack of jurisdiction, motions challenging the constitutionality of the traffic stop, motions disputing the legal definition of driving versus traveling. Each one carefully formatted, each one citing real-sounding case law, each one, when examined by the court, failing on its merits. Callaway filed 11 pretrial motions in 60 days. The judge denied all 11. But here is where the case stopped being routine.
During the discovery process, Callaway's defense, such as it was, requested all available footage from the stop. The body cam recording had already been logged. What hadn't been flagged was the dash cam from the second patrol unit that arrived on scene. That footage captured a 40-second window before the body cam's audio fully engaged. In that window, Callaway can be seen on the phone, not after the stop, during it. Before the officer reached the window, Callaway had already placed a call. The audio is partial and disputed, but investigators noted it in the supplemental report. Who he called and what was said became a point of contention that neither side could fully resolve before trial. It didn't change the charges, but it complicated the narrative. Because now the question wasn't just whether Callaway believed his ideology, it was whether he had anticipated the confrontation, whether the laminated notice, the prepared language, the filmed resistance, whether any of it was spontaneous conviction or calculated performance. That question would follow him into the courtroom. Meanwhile, the Georgia State Bar had opened a separate inquiry, not criminal, professional. A licensed attorney representing himself on charges stemming from a confrontation in which he denied the authority of the legal system he was licensed to operate within. That, the bar concluded, warranted a closer look. 2 proceedings, 2 sets of consequences, running parallel. And Callaway, still insisting he was right, was walking into both of them without a lawyer.
The criminal trial lasted 3 days. Not because the facts were complicated, because Callaway made them complicated. He opened with a jurisdictional challenge that the judge dismissed in under 4 minutes. He submitted a 40-page brief arguing that the court operated under admiralty law and therefore had no authority over a land-dwelling sovereign national. The judge noted it for the record and set it aside. He attempted, during cross-examination of the arresting officer, to enter his laminated non-consent notice into evidence as a legally binding contract. The prosecutor didn't even object. The judge did it for her. What became clear over those 3 days was something the courtroom had quietly understood from the beginning. Callaway was not mounting a legal defense, he was mounting an ideological one. Every motion, every objection, every procedural maneuver was designed not to win the case, but to demonstrate, to himself, to the record, to whatever audience he imagined was watching, that the system had no legitimate power over him. The jury deliberated for 90 minutes. They convicted on 4 of the 5 charges. The lane violation was folded into the broader disposition. Obstruction and failure to identify carried the weight. The judge, in sentencing, noted that Callaway had shown no indication of accepting responsibility and that his conduct throughout the proceedings reflected a pattern of deliberate non-compliance rather than genuine legal dispute. Fines totaled just over $4,000, no jail time beyond time served, 12 months probation. By criminal standards, it was not a severe outcome. By professional standards, it was a different matter entirely. The Georgia State Bar's inquiry had been running quietly alongside the criminal proceedings. Bar investigations move slowly and deliberately so. They are not punitive by design, they are evaluative. The question before the disciplinary committee was not whether Callaway had broken traffic law, it was whether his conduct reflected on his fitness to practice. The committee's findings, issued several months after the criminal verdict, were precise. An attorney who publicly and repeatedly denies the authority of the courts, in writing, on camera, in filed legal documents, creates a conflict that the bar cannot ignore. It is not a political opinion. It is not a philosophical position protected by the First Amendment in the professional context. It is a direct contradiction of the oath taken upon admission to practice, which includes a sworn commitment to uphold the Constitution and the laws of the state. Callaway's license was suspended for 18 months. He was required to complete a legal ethics course before reinstatement could be considered. He was also required to undergo a fitness evaluation, a psychological review standard in cases where the bar questions whether a practitioner's judgment has been materially compromised. He did not publicly contest the suspension. For the first time in the entire arc of this case, from that highway shoulder to the disciplinary committee, Richard Callaway went quiet. What that silence meant, only he knows. But here is what the record shows. A man spent years building a belief system that told him the law did not apply to him. He tested that belief on a Georgia interstate at midnight, armed with a laminated document and 11 years of legal training. And the system he rejected responded the way systems do. Not with anger, not with ideology, but with process. Methodical, documented, patient process. The officer went back to work the next morning. The courtroom moved to its next case. And somewhere in that gap between what Callaway believed and what the law actually holds, there is a question worth sitting with. Not about sovereign citizens specifically, not about traffic stops or body cam footage or bar complaints, about what happens when the framework a person uses to understand the world stops matching the world itself, and how long a person can sustain that distance before something gives. This case was never just about a traffic stop. It was about belief versus law, authority versus interpretation, and what happens when ideology, no matter how thoroughly studied, no matter how sincerely held, finally meets the reality it was built to deny. The body cam footage is 43 seconds long. The consequences lasted years.